Depositions, there's nowhere to hide. No matter what, we won't let you slide. Depositions, there's nowhere to hide. No matter what, we won't let you slide.
How stressful is a deposition? Potentially one of the highest pressure, highest stakes public speaking situations is on the witness stand, in a courtroom, or during a deposition. Even the most experienced witnesses can feel anxiety, which, left unaddressed, can hinder their testimony. But your old Uncle Ed is here to try to make it a little bit easier for you. You know, a deposition can make or break a case because it is the testimony that comes directly from a witness. When somebody files a lawsuit, you don't just go to court and put people on and wing it. There's a lot of homework that gets done behind the scenes to kind of prepare it and make it a little bit less boring for the jury. At least that's the goal. And that happens during the process of pretrial discovery. That involves the exchange of evidence between the parties to try to narrow the issues for trial and help the parties evaluate the case for settlement. And the most pivotal part, in my opinion, of the discovery process is oral depositions of witnesses and parties, where they come in and they take an oath and they testify in front of a court reporter, and then the lawyers are able to go through the transcripts of those depositions and the videos of those depositions and cherry pick certain things that they believe are helpful to their case.
Depositions are so much fun, 'cause we know you got nowhere to run. Depositions, look into the light. Get ready, 'cause you're in for a fight. Depositions, there's nowhere to hide. No matter what, we won't let you slide.
It's a great way to get the testimony of a witness into the record at trial, particularly for witnesses who are located far away or located out of state. It may be very difficult to bring them into the area, get them to come into the state, or get them to show up in the courtroom. You can put them on the TV, and sometimes people enjoy watching that. So somebody comes in for a deposition and they take an oath in front of a court reporter. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Penalty of perjury, my what a drag. When I say oops, I hit a snag.
And one of the purposes is to nail them down on their version of the events that took place. And so it's really important when you're sitting in a deposition that you never guess about an answer to a question. You don't speculate. The attorney who's taking your deposition knows an awful lot about the case, may know things that you don't even know, even though it's your own project file or it's your own personal experience. So it's critically important to review all of the things that you did on the history of the matter, all of the emails that you wrote, all the text messages that you sent, letters that you wrote, documents that you created. You want to be very, very familiar with those, because when you testify in a deposition, since it's under oath and it's testimony in the case, it has the same force and effect as testimony that you would give if you were testifying in court in front of the judge and the jury. So do your homework, tell the truth at all times.
Depositions, you better not lie. Be a man and try not to cry.
If you'd like a fun way to learn about the legal process, please subscribe to our channel and click the like button. Do not volunteer information. If they ask you about apples, don't start answering about oranges. There's a bunch of problems with that. One of the biggest ones is you open the door to a new line of questioning, which could leave you vulnerable. When you're testifying for a deposition, your goal is to get it over with and get out the door. You're not so much there to score points, but to try to do a little bit of damage control. It's not your time to prove your case. That's what happens when your attorney is doing your direct examination at the time of trial. So just answer the questions and stay focused on exactly what's being asked. Answer only as to what you know, and don't speculate. If you're not certain of an answer, be careful with assumptions. They can really get you in trouble. What you say in a deposition can really come back to haunt you at trial. And some attorneys do a good job of laying traps for witnesses in depositions. The witness doesn't even realize what's happening, and next thing they know, they can drive you right off a cliff.
Depositions, I don't mean to be curt, but let's face it, this just might hurt.
With all that being said, try to stay calm. If you come off as argumentative or a jury thinks you're a little bit snappy, that may not be good for your credibility. At the end of the day, like you may have heard me say before, trials are likability contests. The jury's going to hear conflicting, technical, involved, detailed information from both sides of the case, and in many cases, the two versions that come from the two sides sound pretty convincing, but the jury has to pick one to go with. A lot of times the way they do that is based on the likability or the credibility of the parties. It's like, well, this side has a good story, that side has a good story. I don't really know which one is correct, but it seems like this party over here was a little bit more truthful and a little bit more candid, so I guess I'm going to decide in their favor. If you're being asked about documents in the course of your deposition, ask to see them. The attorney is not compelled to show them to you. The attorney could decline and just ask you to testify based on your recollection of those, and you can do that to the best of your ability as long as you're not guessing. So you don't want to come off as being too guarded.
It depends upon what the meaning of the word is. Yes.
But on the other hand, you want to keep the answers pretty short and sweet. If you can answer a question with a yes or a no, do that. But if you don't know or you don't remember, say you don't know or you don't remember, because if you answer a question in a deposition, two things are going to be presumed. Number one, that you heard the question, and number two, that you understood the question. If you didn't hear it, just ask to have the question repeated. If you didn't understand it, ask the attorney to rephrase the question, and the attorney needs to accommodate that request. So don't argue and don't act aggressively in a deposition, even though you may be getting rattled, your blood may be boiling on the inside, but you got to keep it contained. And the last little tip I want to give you is to avoid absolutes when you're testifying. One thing we like to do when we're examining a witness is throw in an absolute term like always or never or everyone or all the time or 100% or perfect, anything like that. If I get you to buy on to a concept like that, all I have to do is show one exception to it, one time where that didn't occur, and then I can point to that, and that may affect your credibility.
Depositions, there's nowhere to hide. No matter what, we gon' let you slide. Depositions, they're very dangerous. You'll feel pain. Financial drain. They know they got you when you're going insane. They make a grown man cry. Won't you make my day?
So don't be afraid of deposition. Fight the fear with the facts. Go in well prepared. And good luck in all of your cases. Uncle Ed signing off.